You can't hear me because it was on mute. That is very good. I want to start over again since you guys didn't get any of that and you just get to watch my mouth move. I appreciate it. Should be able to hear me now, hopefully. Although Chris said that I was muted, but hopefully good. You can hear me now. Well, I'm going to start over. Welcome, everybody. Today is we're breaking off from our previous series called Words Matter, where we are breaking down a homeowner's policy section by section so that you really have an in-depth understanding as to those policies. If you haven't watched that series, you should check out the Facebook page, our website, or our YouTube, where all of those videos can be found. We will be getting back into it. But for today, we've got one hell of a class. It's going to be all about being an expert in depositions. Expert depositions are such a critical part of what I do. As an attorney, when I handle these cases, they can make such a huge difference in the success or downfall, candidly, of a case. So there was a ton of requests. The only thing that might have been more requested than this was for a code upgrade course, which I'm happy to announce. If you didn't see today on Facebook, we are doing it next Friday. We're going to do an entire webinar on code upgrade coverage, when it kicks in, when it doesn't kick in. If you aren't seeing that, if you only get these webinars because I post them onto one of the groups, it means you're not part of our mailing list, or you haven't liked our Facebook page. Our Facebook page is always the first to post about upcoming webinars. So make sure that you like WDB Legal and subscribe to the mailing list at wdblegal.com. Way down at the bottom, you can add your email address in and you'll never miss one of these courses. But the deposition one was incredibly sought after. It seemed like a lot of people wanted some training on this. So I'm happy to do this and provide it as a nice break from that Words Matter series. If you guys have any questions, please use the chat. We've switched the format a little while ago, and it's been absolutely fantastic with the chat. I can throw up comments, answer questions live on the spot without having to type them in, so that everybody can kind of have an open discussion here. It's important because it allows you opportunities to ask me questions directly that you might not have an opportunity to otherwise ask. So please feel free to ask all the questions you could possibly want. I'm sure if you've got a question, somebody else is thinking it either on this webinar or in the future when you can watch these videos down the road. All right, so let's get ourselves started. We are going to talk all about code upgrade coverage. I'm sorry, deposition training. See, I'm already mixing my ones up. Deposition training for experts. When you are an expert, you are one of the most integral parts of a case. It really is make or break when it comes to whether or not there will be success or not. Because what really happens is, as a lot of attorneys refer to it, it becomes a battle of the experts, right? That the case will live or die on the expert testimony and who the jury ultimately believes. So being an expert is really an important aspect of this. A lot of the rules that we have put forward are really focused on expert testimony versus fact testimony. You could also be a fact witness, and some of these will apply to that, but just know that there is a difference between whether or not you are a fact witness in a case or an expert witness in a case. If you don't know, you should absolutely be speaking with the attorney who's representing the plaintiff in the case and find out if they designated you as an expert or not. All right, it says Mike said I'm out of focus. It looks like it's in focus on my end. If it is out of focus on yours, I don't know, I'll do one of these back and forth things, see if it refocuses me. But it looks okay on my end. But let's dive into some of the things you're going to learn. And of course, before we do that, I have to always make some of my critical plugs and my quote for the day. Trust yourself. You know more than you think you do. The reason this is in there is because I'm going to say this 1,000 times today. You are an expert. Anybody on this call, on this webinar right now, or if you're watching this in the future, is an expert. To be an expert, you do not need to be the best person in the field or the most knowledgeable person. You do not need to be an engineer. You don't need to be a roofer. Almost every state has really similar laws for what an expert is. An expert is just someone who has specialized knowledge, whether it be scientific or otherwise specialized knowledge, that could assist a fact finder in determining an issue in the case. So, all of you have more knowledge than the average person when it comes to the construction of a property. All of you have more knowledge about causation of damages. All of these things make you an expert. Again, you don't have to be the best. You don't have to have written the slate roof Bible to testify regarding damages to a slate roof. By the way, if you don't have the slate roof Bible, it's a great book to have in your collection for any slate roof cases. You should check it out. All right. Now let's dive into a few other aspects, some of the housekeeping that comes up. PAGPS. As many of you know, last year we put on our very first PAGPS conference. It's the Public Adjuster Greater Philadelphia Summit. It was a huge, huge success. And there has been a huge outpouring already of people signing up, and space is getting a little more limited. We expanded our space that we had reserved from the hotel. But if you aren't signed up, I highly recommend doing it sooner rather than later. And you can go to pagps2023.com to sign up for it. It is an unbelievable program we're putting on for 2.5 days now. We expanded it further to extend credits. It's going to be between 10 and 13 credits. And I think, and I would challenge somebody to find a better deal when it comes to live education. I think it's probably the least expensive 2.5 day conference that exists out there. We're trying really hard to keep that cost low because it's important from both myself, Holly Soffer, who is helping me out on these MAPIA organization, or APIA, the national one. All of us really want to get education tools out there for public adjusters so that they can improve this industry as a whole. If you aren't signed up, I can't stress again, you really should. We had a great time. It wasn't just all learning. There was an open bar that you guys will be able to partake in. Really good food. Actually, one of the most surprising aspects of the whole conference was how fantastic the food was. We're also going to be supplying karaoke this year. So anyone who wants to come watch me or some others make fools of ourselves, or perhaps make a fool of yourself doing some karaoke, you should absolutely come out and check it out. It's just outside Philadelphia in Cherry Hill, literally about 10 minutes from the airport. It's a really great little venue that we're at. So please think about signing up. Thanks, Jason. The karaoke will be fun. So take a look at it. Go to the website. If you need to have a link that you're too lazy to type it in at this point, hey, use your phone and just scan this code. I was really proud to figure out how to do the QR codes. So you can just scan that and get to the website as well. All right. Let's talk about what we're going to do. We're going to go through a number of things in this course. We're going to talk about preparation for the expert deposition. The preparation is such a huge aspect of being good in a deposition, having the knowledge, having an understanding as to what everything is about, because a lot of times these depositions can happen months, even years after your adjustment of the claim. So you want to make sure that you've refreshed yourself. We're going to talk about some of the key tenets of good expert testimony, all the things that you always want to be thinking about and remembering as you're going through and testifying at the deposition. We're going to talk about how to answer questions. That's one of the biggest things excuse me, that people are curious about, is how do you really properly respond to a question in the deposition? We're going to go over that. And we'll talk about what to do after the deposition, because there are steps that you can take to potentially make the case stronger. So we will talk about that as well. Going first into the preparation, I can't stress enough that preparation really does matter. It's important when you're doing deposition testimony to have a great understanding as to what the case is about. So the first step in doing that is creating a really good expert report. If you were to see some of the ones that I see from adjusters as an expert report, you would look at it and say, what is this? I don't understand what you're trying to say. It's the formatting is all strange. It just doesn't look good. It doesn't look professional. So you want to realize that this is a document that the judge is going to be reviewing, the jury is going to be looking at potentially, and it's going to make a difference that you present it as professional. So you want to learn how to do simple things like formatting properly in Microsoft Word so that you have a header for a section in your expert report. Make it look good. If you need sample expert reports, please reach out to me. I am happy to provide them to you so that you can say, hey, this is a good kind of baseline for what mine should look like. Let's do that. But your report should generally be broken down into the same sections over and over again. And you're going to start off with your background. And this is your opportunity to brag, and you should brag. Your background is one of the most important aspects of your report because anybody that reads it is going to look at that and say, why should I trust you? Why are you a person that I need to listen to when it comes to what caused the damages or what repairs need to be made to the property? And you want to talk about everything you've got. Perhaps you worked for a carrier for 10 years before becoming a public adjuster. Put that in there. And put that as when you were working for that carrier, you made claims determinations. You reviewed policies for policy interpretation. You determined the damages. Everything that you did in that job, you want to put it out there. And the same thing for your time as a public adjuster. Talk about all the training that you have. Talk about courses that you do online like these, where you learn how to interpret policies, to look at damages, find out what repairs are necessary to roofs. Talk about your CE credits that you're required to do, and 24 credits in most states, 24 credits every 2 years. Don't quote me on that because I'm sure there are other rules in other states, but that is generally what I say. Um, all of that stuff should be in there. Any certifications that you have. Are you IICRC certified? Do you have the Hague certification for roofs? Courts love the Hague certification despite some of the weaknesses that Hague obviously has. But a lot of those certifications just scream credibility. They scream you're someone that should be listened to. You're not just a public adjuster. You are so much more than that. You are a culmination of all of the inspections you've done, of all of the properties that you've been to, of all of the policies you've reviewed and claims that you've handled. It's so much more, and that's your chance to really explain it. And it also explains how you know what you know, right? How do you know that there is wind damage to this property? How do you know that the water damage wasn't more than 14 days or more? That all that background is that basis. The next section of your report should always outline your investigation. What did you do, right? And if you go through who, what, where, and whens of the investigation, it outlines it kind of by itself. So you want to talk about who was at the inspections with you. Did the carrier send out an engineer or their own adjuster? What was the process for what you did? Did you walk through the property, take photographs of each room on a broad spectrum and then individual areas of damage? Did you walk around the exterior? What did you do when you are there? The more detail, the better. And I can't stress that enough. Detail in reports is what changes a winning report to a losing report, or well, strike that, a losing report to a winning report. You want more detail. You want to talk about the wheres. Might be obvious to you, but you want to restate, I inspected the property at this address. And go through that and make sure that that is in your report, along with when it occurred. And the when is one of the top things that I actually see missed in reports from adjusters, and candidly, all experts. They don't indicate when they were either at the property, when all the multiple dates that they had actually gone out, or when the report is being drafted. Right, there's a big difference that I can make as an attorney between an expert who inspected a property in January of 2020 and wrote their report in January of 2023. Right, you've got 3 years in between those two timeframes, and you've probably forgotten a lot of information. So where did you make up that difference? Versus, oh, I inspected January 2023, wrote my report the same month. That is really important information that can make a difference. After you go through your investigation and what happened at the property, what you did to investigate it, you then go into your findings. What did you determine when you were actually out there and you got to see that water damage on the wall? This is by far the biggest weakness in every public adjuster's report that I've ever received. And candidly, it's a weakness in almost every report that I ever see, regardless of it being an engineer or someone else. And what you will do, and when I say you, the collective you as a public adjuster, will put this letter report together and you'll just say, I went to the property, I got up on the roof. I inspected. I found multiple shingles that have hail damage. You know, 82 shingles had wind damage, and the proper repair is to replace the roof. Okay, great. That sounds pretty good, but how do you know it's hail damage? How do you know it's wind damage? What is it? You need to explain to the person who is reading this report why you know it's wind damage. Was it that I saw creases in the shingles and I looked into the weather reports that showed that the winds were 52 miles an hour? And because these shingles are, 13 or 20 years old, they are more susceptible to wind damage, and the creases show that they were actually lifted up during the storm and caused a crease in the shingle. Fantastic. You've got to put it in there, right? Or with hail damage. And I use these because, wind and hail are such easy common claims. Hail damage, I saw an indentation in the roof. Some of the granules were actually imprinted into the center of it, creating almost this donut shape that's consistent with hail damage. These damages were found on multiple slopes of the roof. See my photographs, 1 through 25. That type of information needs to be in there so you can explain the why. Explaining the why is so important. I really want to drive that home. If you're going to do these reports and prepare properly as an expert, you need to explain why you're finding the damages that you are finding. Last but not least, you want to summarize all of this in a conclusion. The truth is, most of us attorneys, when we get an expert report, the very first thing is we turn to the end and we look at the conclusions. It provides a really nice summary of, hey, these are my findings. So in that wind and hail case, I found 72 wind damaged shingles on multiple slopes of the roof, evidenced by creasing or torn shingles. Line 2, I found 85 hail damaged shingles in the test squares on 4 of the slopes, evidenced by the indentations and granule loss and fracturing of the mat for those shingles. Fantastic. And just bullet point those conclusions. All of the explanation is above, but you get your conclusions right there again at the end. The courts are doing the same thing. They're looking right to that conclusion section to see if there's a quick summary of what's going on. So you want to make sure to have your conclusions outlined. All of these should be, again, in every single one of your reports. Here's a real key aspect. This report can just be a letter. Doesn't have to be anything more fancy than that. A letter with some good headers on it does the trick. And almost every single case, I honestly have a hard time thinking of one that should have one of these before you even send it to legal. And the reason being is you want to put the carrier on notice of your exact position, exactly what you are trying to tell them. And when you do a dispute letter, it should be outlined just like this, so that whenever you send it to an attorney, you can send this report and say, hey, I put the carrier on notice of all of these things. Here's my report. They ignored it. It can be a great basis for a bad faith claim if the attorney can use it properly and the facts line up to say, hey, we gave you all of this information. You ignored it. One of my biggest frustrations whenever I get a case, and I can nearly guarantee there are some people on this that have done this, I will get a file from you and it won't have any dispute as to the denial. Nothing will be in writing as to what went wrong, why the carrier was incorrect in their findings. Every claim should have a dispute letter if you're going to be sending it to litigation. If you're just going to give up and you've gotten the money that you need, obviously no dispute letter is necessary. But if you're going litigation, every single claim should have a dispute letter. What's nice about that is you can have these as preset forms. If you use a good management program, you can have a form letter that's your dispute letter, so you don't have to do things like retype your background. And you can kind of do plug and play for things like your inspection because you'll have a system in place. I hope that makes sense. Jason had a question. Most of my, the whole thing's not going to be on here, but most of my claims are house fires where the what and when are generally obvious. Would you suggest performing an opening report as a PA on a claim we are handling? Or is this more when we already have a subpoena? Well, hopefully I answered that. You should have it in every single claim. You don't necessarily need it as an opening. How you handle your claim, if you want to send that out before the claim even gets inspected by the carrier, I could see a lot of strength to that. I could also see strength in having conversations with the person, not putting them on the defensive. I can imagine there are some adjusters for insurance companies that if you were to send this report before an inspection even happens, they're going to go in with a defensive posture. But then there's others that I could see also saying, oh, great, he already told me everything that's going on. I just need to go to confirm what he already wrote, and this inspection can go a lot faster. You're going to want to play that by ear based off of the adjuster and the particular situation. So it's not something you want to wait on until a subpoena, but depending on where in the claim you are, you might adjust when that is going to happen. Is this pre or post initial meeting scope with the adjuster? I think that was probably addressed in that one as well. All right, so you want to get that expert stuff taken care of, again, before you ever get this into litigation. But let's assume things went wrong, right? And the carrier, shockingly, I know, didn't pay everything they were supposed to on a claim or wrongfully denied it, and you had to send it to an attorney. First and foremost, hopefully you all have an attorney that you work really closely with, because that relationship is really important when you're doing things like the expert reports and deposition prep. You don't want the clients to just go to any Joe Schmo, personal injury lawyer that just might have insurance bad faith listed on their website. This is a niche practice for a reason. Understanding policies and understanding these claims is nuanced, as you're well aware, and you really should make sure you're working with a professional that does this on a regular basis. If you have any questions about that or want to ever discuss it, obviously feel free to reach out. But you get to the deposition, you get a deposition notice, and uh-oh, I'm going to be deposed. I didn't put this on the slide, but the first thing you need to find out is, are you being deposed as an expert or are you being deposed as a fact witness? Might not seem like there's a big distinction there, but there is one huge distinction. And the big distinction is your opinion. Fact witnesses do not provide opinions. They don't say what they ultimately concluded as the result of factual information. They are just, I went to the property, I saw X, Y, and Z. It's not, oh, because I saw X, Y, and Z, I know X or, A, B, C opinion as a result of that. You want to talk to your attorney that is handling that claim, because that will change depending on the state, what court you're in, a bunch of different issues, what you're allowed to say and what you should say in the deposition. If you're not there to provide your opinion, you shouldn't be giving your opinion. So you get your notice for deposition. What are some of the things that you should do? You want to review a lot of information before the deposition, and not just like a couple minutes before. You want to do this a couple days before, because questions might arise based off of what you review, and you want time for the attorney to be able to get back to you about that. Obviously, you want to review your report. No brainer. You want to get copies of any opposing reports from the other side and review those as well. One of your biggest jobs as an expert is going to be supporting your position and your opinion in a deposition. And you're going to need to be able to support that despite bad evidence that will inevitably come out, right? If no case had bad evidence, it wouldn't be a case at all. So you want to know what the other side's opinion is. If you get a chance to review their report, you can go through and say, oh, wait, this is BS. And here's why. This thing's completely wrong. Oh, they're relying on the wrong information here. You can have that prepared and ready to go. Goes without saying, you need to speak with counsel for the property owner as part of your preparations for it. And you want to find out a few things. You want to find out first what their plaintiff's main arguments are, what has kind of shifted, or if it's stayed the same when it comes to the arguments for the loss. It's not always the same. I have gotten multiple claims that I've been involved in where I get it afterwards and have to shift the argument for the case. A perfect example are claims of vandalism by tenants. There's a huge dispute that I'm sure a lot of you have dealt with, where the carrier comes back and says, oh, this isn't vandalism, it's hard living. Okay, I don't know what hard living means, but can you show me in the policy where it excludes hard living? And what a lot of public adjusters will do is they'll keep pressing it as vandalism. It might not be vandalism. I hate to break it to you. Vandalism is a very specific type of crime where they are purposefully and intentionally damaging property. Hard living is far more than wear and tear, though. So they want to deny hard living, calling it wear and tear, but that's not normal wear and tear, right? This is something way over and above normal wear and tear. So we had to shift the argument in that case to say, look, at worst, this is vandalism. At best, it's hard living. Both of those things are covered because it was an all risk policy. So you want to make sure that you speak with the attorney to know, hey, this is the theory that we are pushing forward on the claim. The inverse is also true. When you speak to the attorney, you want to find out what the defense has been pushing as the issue in the case. Maybe it's something that wasn't even part of the adjustment of the loss. Maybe all of a sudden the case is entirely shifted to a residency issue because of some questions about where the person was living. And that's really what they've honed in on. And they've kind of given up on other issues regarding, let's say, how long the leak was going on. So you apologize about the beeping. One of my staff is making strombolis for the rest of the staff. So if you heard that, that's what that was. So Brian Singer asked the question, hard living is covered. Absolutely. I just had a successful case against a carrier where they were claiming hard living. And they were saying, well, hard living is just wear and tear. No, it isn't. Wear and tear is the normal expected wear and tear that a property is going to have over time. It's, oh, my chair might hit the wall as I'm backing up from my desk and causing some problems. It is not the damaging of cabinets and ripping them off of walls. It's not doors slamming into walls, creating holes with the door handles. That is something over and above wear and tear. If hard living is the best word for it, so be it. But there's no exclusion within the policy for this quote hard living. So you talk about the defense's theories on the case. You talk about the plaintiff's theories, and you want to make sure you are prepared that how to handle the bad facts. Like I said, every case has bad facts, right? It wouldn't be a litigation if they weren't there. Maybe it's that the roof has prior damage from old photos. Maybe it's that the clients weren't at the property for 3 months and you've got to deal with how long the leak was occurring. These things can happen. You want to make sure that you're prepared for explanations because that's one of your jobs. One of your jobs is to explain that so that it's not just coming from the attorney's mouth, it's coming from an actual witness's mouth as well. Yeah, unfortunately, there's not enough stromboli. I apologize for all you guys. However, I'd be curious if I ever moved these to in person, if anyone would actually come, I'd be happy to actually supply lunch. The two things that we're looking into doing, just as a quick aside, is in-person CE credits if I were to come to your office and do them for a group, or have them here so that you can actually get the CE credits live. If that sounds interesting to anybody, let me know. All right, so that's the stuff that you're going to want to review before the deposition. You can't review too much. You want to be the expert. You want to have the knowledge that is in that information, so make sure that you review it. On top of that, there are some tenets of expert deposition testimony that you always want to remember. And I want to really stress a lot of those with you guys. The very first one, and I want to drive this one home, is confidence. My number one complaint of a public adjuster testifying in a deposition is that they are, oh man, I think it keeps going, that they are not confident with their answers. That for some reason, when I talk to you, you're the most confident human being on the freaking planet, that you are absolutely right. You know exactly what is going on. And then all of a sudden you sit down in that chair and it becomes, well, I'm not an expert. I'm not a roofer. I don't really know. Maybe it's this. I think it's that. It could be other things. It is the most frustrating thing as an attorney when you go through all these steps and that happens in a deposition. You need to recognize, I'm going to say it again, you are an expert. You're an expert in all of these issues. Even if you've been on 5 roofs, you are a roofing expert because it's 5 more roofs than the average person has ever stepped on. So you have that knowledge. You need to be confident in your responses. You need to be sure that, are you telling me, you put in your estimate that all of the tile needs to be replaced because of one broken tile in the kitchen? Absolutely. There's no question. It is not, well, I think that's the case. Maybe they could try to do something. No, confidence is key. Can't not stress that enough. Question from Scott Wolferts. Are we allowed to have notes during our testimony? Absolutely not. Can't stress that enough. Not. You do not want to have notes in front of you. And there's so many reasons for that. Number one, if you have notes in front of you, they are discoverable. They are something that the other side could take and even ask on the spot, what are you looking at? Number two, it takes away from some of your credibility. If you're just going down and reading all of the facts and information, it takes away from what your true opinion is. If this is true, you should be able to have those opinions regardless of having the notes in front of you. Now, there is a caveat, and I think I talk about this on one of the slides, but I'll say it now. You can get your report to put in front of you to refresh your recollection. Again, a lot of this happens years after you might have inspected the property, and perhaps you don't remember something specific despite all of your prep and all of your review. Maybe you don't remember the date of something. You can say, hey, I don't remember. I'm pretty sure it's in my report. Do you mind if I take a look? And they can supply that to you so that you can take a look at your report. But you should not have notes. You should be an expert without notes in front of you and know what is going on with this case. So you need to have confidence. Number two, you need to have confidence. Number three, you need to have confidence. Am I driving this home yet? Is it making it clear, hopefully, that there is some understanding that you need to be confident in your answers? You should never have maybes or I'm not sures when it comes to the things that you're testifying as an expert on. It's okay not to know everything. It is perfectly fine to say, I don't know to an answer to a question, but it better not be, I don't know what really happened to that roof, right? That should never be the I don't know if you're going to be an expert. Because if you don't know, you shouldn't be the expert, right? You should be finding someone who does know. Get a roofer out there. Tell the attorney, hey, I can't confidently testify about this. You need to know the answers and have confidence and stand by that, right? You generally are going to know more than the defense attorney on the other side. Most defense attorneys that I work with become very laser focused on one issue of a case and don't really look at broader pictures, or they become laser focused on just the issues of the one file, never seem to really carry it over to other claims. So you're going to have more knowledge than they will for the day-to-day inspections, the damages to the roofs. So explain that in there and make sure that you've got that confidence. Okay, now that I've driven that, other things that I want to remind you guys of. You don't need to agree just because the question sounds like you need to agree. Attorneys do this lovely thing called leading questions. We're allowed to do it in a lot of scenarios, and we use it as a tactic. So we'll say things like, well, wait a second, you weren't there on the day of the storm, so you don't really know what happened. Isn't that right? And a lot of people would have that quick temptation to say, no, I guess I don't really know because I wasn't there on the day of the storm. And I could understand that gut reaction. But if you're an expert, you absolutely know what happened. You don't need to be there on the day of the storm to know exactly what happened as a result of this storm, right? You can do things like look at the weather data. If you look at the weather data, look at the damages on the roof, take a look at pre-loss photos from things like Google Earth, you can put together a picture that you know exactly what happened without having to actually be there. So just because a question sounds like you're supposed to agree doesn't mean you're supposed to agree to it, right? You can say no. You're also allowed to change your mind. I talk at length, and I'm going to say it 20 more times about being confident. And I'm going to even throw up this question just because I want to drive it home, where Mike Muma asks, please help me understand. Are you suggesting we should be confident? Absolutely. But confidence doesn't mean you can't change your mind. You can. If, for example, this has happened to me in cases, you put a claim in for roof damage to a property, and all of a sudden a home inspection report comes out because they subpoenaed the home inspector, and they show some of the shingles had been torn off. Previously, they were missing when the home was inspected 4 years ago. Okay, absolutely. You have to be able to roll with that and say, look, if there's previous damage, we certainly could review that, but that doesn't necessarily mean the whole claim's not covered. You see in this photograph how, these 3 shingles are missing on the one slope of the roof. Well, in my photographs, there's 17 that are missing. So sure, 3 might have been missing before, but we've got 14 more that have been added on as a result of this storm, and those are covered. And it doesn't matter that there were 3 missing before. That's the property you insured, carrier. So you still owe for the damage, even though there was this prior information or prior damage. So don't be afraid of having to adjust to admit that something isn't right that you had before. That's okay. It happens. And you lose credibility if you try to lock in on the wrong answer. I've had a few experts who have sat down and just keep saying, well, my opinion is the roof's damaged by wind, right? My opinion just stays the same. You lose credibility by doing that. And especially when you're testifying, you want to be able to roll with those punches and adjust accordingly. You don't need to be a computer and remember everything. As I talked about, you can refer back to the report, but you only want to do that as necessary. If you do this right, you shouldn't have to review your report during the testimony because you already reviewed it a ton before and you're super up to date and familiar with it. I tell another thing to all of every witness I have. You want to be the most likable person in that room. One of the number one things that a person takes a deposition for, especially from the defense, is to figure out what are you going to be like if we go to trial? Is the judge going to like you? Is the jury going to like you? Are they going to think you're a credible person? Do they think you're honest? All of these questions are answered in a deposition. And if you are that likable, confident person, you will portray all of that and scare them into a better settlement number. You always want to remember professional, polite, and honest. Those are the most important things. I don't know how many ways to say it. You just need to make sure you are always professional, polite, and honest. We're going to go through some examples of real life things that have happened in depositions that I've been at where that's not always the case. So some other things you always want to keep in mind: the theory of the case, right? Are you pressing that this is storm-related damages versus, man-made construction from a contractor? I just got off the phone with someone where the carrier denied the loss because they said this isn't storm damage. We think that this is actually created by a person. And the public adjuster shifted, as they absolutely should have, and said, you know what? I think you might be right. Right? I don't have to lock into storm damage. I think you're right. I think a contractor was up on this roof previously and caused this damage. But carrier, that's vandalism. This is still a covered loss. The carrier refused payment on the claim, and we're assisting them with it. So, you need to recognize that you're going to push a theory throughout this, and remembering that theory is going to be really important because you're going to want to ask yourself, does the question I'm answering, does it affect that theory in any way? Right? Does it change whether or not I'm going to be right or potentially wrong when someone else looks at this, and try to make sure that you're answering it appropriately? A lot of questions just don't matter, right? Where'd you go to high school? I don't know. It just doesn't matter, but here's the information anyway. So some of it just might not have any effect whatsoever. You also want to listen for objections from your attorney. The attorneys will generally, for example, when I have you as an expert witness, I will represent you for the purposes of that deposition, so that I'm actually your counsel, but only for purposes of the dep. And I can object and provide guidance to say whether or not you should answer a question or not, and do a few other things. So you want to listen to the objection so that you can have some sense of what you're supposed to do next. If they don't object, you're going to need to answer. So don't try to object to your own questions. You also want to know what your hourly rate or flat rate is for the deposition, right? A lot of experts should be disclosing that right from the beginning and get clarification from the other side that you're agreeing to make payment for this. A lot of states, have laws in place that require experts to be paid by potentially the other side. And if it's one of those states, you want to make sure, and you should talk to your attorney about this, putting it on the record of what your hourly rate is and the defense's agreement, to pay you, so that you've got that information as well. And if it's a really large case, a mock deposition might be appropriate, where either the attorney for the case itself talks to you, or help. If you really need help with something, give me a call. I'll spend 20 minutes with you and see if I can help out. If you feel like for some reason you're not getting the assistance you otherwise need. But a mock deposition could be helpful. We've got another big question that always comes up, is how to answer the actual question, right? All these tenets, all these things are about things you need to remember as you're answering the questions, right? The theories of the case, how it might affect the outcome. All of that stuff is really important, but how do you actually answer the question, right? What's the best way to do that? Let's dive in. There are a few rules that are really hold fast for anyone who is doing depositions, especially at the beginning of their careers doing depositions. The first one is short answers. Short, direct answers are the best thing you can do, especially when you are new to taking a deposition. short and direct. You do not want to give long-winded, rambling answers about information. And as you get more skillful at depositions, those reins can start getting pulled back and you can start having some leeway to answer more, but you really want to do the job of just answering the question that they ask, short, direct, and to the point. Now, when you do answer the question directly, this is a rule that is flip-flopped for trial. I can certainly explain in detail why that is the case, but ask me individually rather than me just posting it online everywhere for everyone, defense attorneys to look at. But when you answer a question at a deposition, let's just say, do you believe that there was any wear and tear to this roof? Your answer, you're going to want to answer that question, right? Whether the answer is yes or no, it doesn't really matter to me, but you're going to answer that question at the very end. So maybe you go through and say, look, there was a lot of damage to this roof. The wind storm had come through and caused damage to the shingles. It had lifted them, breaking the seals. A number of shingles were missing. Others had creases. I mean, it was really throughout this roof. But when it comes to your question, perhaps there were some other areas of wear and tear. Okay, but you do that at the end. You answer the question at the end. I can't stress enough, this is polar opposite of what you will do in trial, where you will answer the question and then provide your explanation. There is a very good reason for that, at least in my opinion. So think of that as you are answering these questions. Some other rules of thumb that you always want to stand by. Tell the truth. It shouldn't have to be said. It should be obvious to everybody. I've had at least a few who have said things that I have realized in the future, afterwards, might not have been entirely accurate, and it really pisses me off. But beyond that, it's also a crime to lie under oath, and it doesn't actually help anyone. I can't think of a situation where somebody has made a false statement on a deposition, in a report, or otherwise that hasn't come back to bite that person in one way or another. You don't want to be that person, so just tell the damn truth. You also, to that extent, don't want to use qualifiers. You don't want to say things were huge or small, or there was a ton of it, or just a few of it. It just is what it is, right? Is there damage to the ceiling? Water damage? Yes. Not, oh my God, there was a ton of water damage to the ceiling. You don't need it. It doesn't help anything. And it only gives an opportunity for someone to come back and say, wait, you think that's a ton of water damage? That's 1 foot, square of water damage. It gives a reason for someone to just disagree with you that isn't necessary. It is what it is. It's just damaged. Okay. If you don't know something, just admit to it. It's okay, right? We can work it out. You can supplement the information later if you need to. If you just don't know what year the house was built, okay, I don't know what year the house, I'm sorry, I just don't know. You don't want to guess. You don't want to do even guesstimates when it comes to information that might affect the case. So you can simply say, I don't know. But you could also add in, I don't know, but to be honest, it doesn't really affect my opinion on this case, and give the explanation as to why. Some bad facts are unavoidable. They're going to happen. Every deposition I've ever been in has had an expert that has been confronted with bad facts. You can admit to them, just be prepared because you prepped with the attorney on why that bad fact either doesn't matter, is irrelevant, or doesn't actually apply to whatever situation you're talking about. So again, we use the prior damage to the roof. Look, Carrier, you said that there was 3 shingles that were missing before. I now see that in the photographs. That's perfectly fine. It's still the roof you insured. It's still covered because there was 14 other shingles that were damaged, whatever the case may be. When they're really getting off track, you can always try to pull them back. And this is one of those things that becomes kind of practiced. It's difficult to do, to pull an attorney off their own line of questioning. But if you push back on a question and say, look, you keep asking about this wear and tear. I'm telling you, yes, there was wear and tear to the property, but you're not focusing on the thing that's most important, and that's the wind damage to the shingles. And bring it back to your theory of the case. Bring it back to the thing that you're trying to talk about with your answers, and it can do a nice job of making sure that throughout this deposition, your theory is driven home over and over again, and it might make the attorney actually move on, especially the younger, less experienced attorneys. Do not Every single thing on this list, and I think it goes into the second slide if I remember correctly, have been things that I've actually seen in depositions. So I have to put them in here because some of them I thought were obvious, but they're apparently not. So do not fight or be combative with the defense attorney. You need to be the likable person. The likable person doesn't do things like yell. So don't yell at them. The likable person doesn't do things like storm off because they're getting annoyed by the same question being asked 17 times. You need to just be professional, honest, kind throughout this process to be that likable person. They want to rattle you. They do. That's what attorneys do. You don't need to fall for it. You've just got to put that smile on and keep pushing through. The asking why is this relevant, right? A lot of times this comes up where an expert will say, oh, why is that relevant? It's not your job to know why it's relevant. It's my job to know why it's relevant. If I didn't object, there's a reason I didn't object. Answer the damn question. So don't try to be the lawyer, right? You're not the lawyer. Don't know what to tell you. It's just not the case. Maybe you know more than some lawyers. That certainly could be the case. But when it comes to being in the deposition, you are not the attorney. You've got to answer the question unless you're told not to. So just don't fight back. Don't drink. I don't mean water, by the way. I have had a deponent actually pull out a bottle or it was a can of beer and drink while the deposition was occurring. That was bad. It was really bad. Don't do that. Don't smoke. I've had a few experts, actually, this is more than one, actually light up and smoke during a deposition. Do not do that. Don't be shirtless. Wear ideally a professional shirt. Most depositions that you're going to be involved in probably won't be video recorded. But again, you're presenting yourself in some degree as to what they should expect to see if you're going to be going to trial. So if you show up in a tattered t-shirt, from Guns N' Roses, might be a really freaking awesome shirt, but it doesn't exactly show signs of professionalism. Versus if you show up in a button-up shirt or a polo. That's the mentality you want them to have is, oh, this person can clean up nicely. It's going to be someone who, could be an issue if they're going to testify to, sorry, I just read Mike's comment. If they're going to be testifying in court, they're going to show up and clean up nicely and be trusted. Don't ramble on. I know it's a fantastic song. I love Ramble On, but when you're in a deposition, you absolutely should not be rambling just to try and keep talking more than the other side. Here's a trick. I don't know if you knew this or not. The more you talk, the more questions are going to be asked. So if you have any desire for this thing to be over, you don't want to ramble. You don't want to tell jokes or be sarcastic. This one actually comes off a lot because I tell people, oh, be the likable person. And that tendency is, oh, to be kind of joking and cavalier with the other side. Off the record, it's perfectly fine. It can create a good rapport. But on the record, if they were to ask a question like, oh, this shingle, wouldn't you agree that's wear and tear? And you say something, yeah, that's wear and tear, sure. Right? It might come off sounding super sarcastic, but when that court reporter types that down, sarcasm isn't picked up. They don't get to do that. It's like texting it to somebody. Sarcasm doesn't come through well, and it can be used against you later on. So don't do things like telling jokes and being sarcastic. Assuming things. You don't want to assume anything. One of the biggest problems that I actually deal with constantly myself, but experts do it as well, is this concept of called the curse of knowledge. And it's not that I'm super knowledgeable. It's that we've lived a case for so long that we know the ins and outs of it. We know every aspect of this file, up, down, left and right, forwards and backwards. And we forget that the people we're selling this to, the people that we're trying to convince or talk to about this, don't have all of that knowledge. So when we talk to a judge or a jury, it can be really hard sometimes to remember we got to go through step by step all the details and not make the assumption that they're going to just understand because it's something that we say. So you want to do the same thing and not make any assumptions whatsoever when it comes to answering a question. If you believe a question involves some level of assumption at all, ask for clarification. You can always stop the attorney and say, I'm sorry, I don't really understand the question. Are you saying X? Are you saying Y? Could you rephrase the question? In some way, get them to rephrase it so that any of those assumptions are clarified and clear. So we got a very good question here from Ian. Are deponents required to answer hypothetical questions? Hypothetical questions are a great trick that attorneys use. We use it to try and forward our theory of a case, right? Assuming X is true, wouldn't you agree to Y? Here's the answer, Ian. You're going to have to answer the question, but you don't have to answer it the way that they think you're going to answer it. Most attorneys, when they prep anybody for a deposition with hypotheticals, they'll say, look, if you're provided a hypothetical question, create questions of your own, right? That these things don't exist in a box. So there are other questions that might be important to know for the hypothetical. And candidly, you can push that to the nth degree so that there's no way that they could actually coherently and clearly ask a hypothetical that gets an answer. So if they were to ask, well, wouldn't you agree if the wind on that day was only 23 miles an hour, that the roof likely would not have sustained wind damage? And your answer could be something like, well, there's a few factors that go into that. What is the brittleness of the shingles in your hypothetical? And they're going to say, okay, well, this exact roof, right? This roof, 23-mile-an-hour winds, would that have caused damage? Well, it depends. Are they straight line winds or are they swirling winds? What direction are they coming from? Are they coming up from a corner of the roof? Straight winds? Are they? You can create all of these questions that could ultimately make the hypothetical completely useless to the other side in any way because they never really get a clear answer from you. However, if they find some way to get to that clear answer, you are going to have to provide an answer. Again, unless your attorney tells you not to answer, if you're an expert, you're allowed to be asked hypothetical questions and you're going to have to answer those. But it's the attorney's job to stop that if they're not allowed to do it for any reason. So trust that attorney. You can always clarify the hypothetical, and you should. If they ultimately get that question out, you could say, in the hypothetical, perhaps. And you could say, I don't really know. That's fine. Perhaps it's true, but that's not what happened here, right? That's not the situation we have for X, Y, and Z reasons. So you can, again, bring it back to your theory as to why the hypothetical is useless anyway. All right. We've gotten through the notes, or jokes, I mean, and don't assume anything. Do not be driving a car. I've had a number of experts who come up for a deposition and they sign on, and all of a sudden we realize they're driving from one inspection to another. If you are being deposed, be in one place, be professional, and be prepared to be there as long as you need to be, which is the next one. Don't expect it to be over in an hour. Depositions aren't always quick. Sometimes they are. Sometimes they can be 20 minutes. It's rare, but you're not going to be done in most cases in an hour. So just properly allot your time so that there is, you aren't concerned about, hey, I've got to go pick up my kids in 20 minutes. I've got to end this thing. It's not helpful for anybody involved for that to be the case 99% of the time. Because it only gives the other side time to review your old testimony, prepare new questions based off of it. It can get really messy. Ian, another good question. Can PAs insist on being paid hourly if deposition subpoena is issued by the carrier and not the insured? It depends. So every state has different regulations, and candidly, it's not just every state, but also whether it's state or federal court has different rules about payment of experts. Generally, you can always be compensated hourly if that's your agreement with your attorney as the expert, but it really is going to depend on the state as to who is going to be the one paying for that deposition. You don't want to talk about conversations you've had with counsel. Conversations with counsel in every state I've practiced in are protected under an attorney expert confidentiality. So you don't have to disclose that. It's not something that should be talked about unless, of course, your state has a different rule. Obviously, talk to your attorney about that. But just generally, no, you shouldn't be talking about conversations you had, with your attorney. Tell them you don't want to tell them where to find answers that you don't know the answer to. Really common, and this goes for fact depositions or experts. You might say, "Oh, I don't have that information, but I know my office staff would know that." You don't need to add that in. There's no benefit whatsoever to telling them, where that information can be found, especially if they're not asking for it. The other problem, even if they do ask for it, is what if your staff doesn't know? What if they don't have that email saved? And this goes to the document issue. What if you don't have the document? I have had more people than I could possibly count swear up and down in a deposition that they absolutely have photos of the loss before, photos of the property before the loss, or copies of my tax returns, or, any other miscellaneous document, a home inspection report. And they really believe it. They think they do have these documents. So they're not lying, they're just wrong. And they go back and they look for it, and all of a sudden it doesn't exist. So it looks like you're hiding something when you say under oath, I have this document, and then they make a request for it and they don't have it anymore. Do not make that mistake. Do not give them the opportunity to question your credibility by forcing you into a situation of, well, you said this here and you're saying this now. When were you telling the truth? So make sure that you're careful about that. So some of these issues, Mike, by the way, are post 2022 when things became remote, but other ones are not. I mean, a lot of the things like fighting and pushing back and trying to object to your own questions are definitely old ones. The other thing that's really difficult for experts not to do is estimate, and I don't mean putting an estimate together for the loss. What I mean for is saying, like, how old is this property? It's a really easy example. Some Most people will want to say something like, "Oh, I think it was built, around 1960." Okay, and maybe it was. Maybe that's accurate, but I can tell just by the way you answered that question, you don't really know the answer. So when you're asked to estimate things, what you should do is give a range whenever possible. So, easy example, how tall is one of those books that's behind me? I have no idea exactly how tall one of those books is, but I can tell you with absolute positive certainty that it falls between 4 inches and 2 feet. And that should be my answer. That, if I had to estimate, I would say it's somewhere between 4 inches and 2 feet tall. Because I know with absolute certainty that the correct answer falls within that mix. I wouldn't want to say, oh, I think that book is about 10 inches tall, right? Because they're going to come back and say, oh, well, you're actually, 3 inches off. That can just create problems for absolutely no reason. Chris, fantastic question. Would you consider most PAs to be a fact witness of the claim and the claim process instead of expert witnesses? I would consider an expert witness to have no financial interest and no bias. Is that correct? Partially correct. So you are, without question, a fact witness. There is really no ifs, ands, or buts about that. Um, Jason, there's no ifs, ands, or buts about the fact that you are a fact witness. You went out to the property, you saw things, you did inspections. All of that is factual information. When it comes to being an expert, though, again, the first and most important qualifier is that you've got specialized knowledge that the average juror does not have and would be helpful to help them decide the case. When it comes to financial interest, that's generally going to be based off of state law. There are some states that say you can't have a contingency agreement in place and be an expert witness. But almost every expert in every case has some financial interest because they're being paid as the expert. So it's not that you can't be paid, it just can't be based off of a contingency fee. So just know that that's in some states going to be questionable, but in many it doesn't matter. You can keep your contingency fee in place and still be an expert. And what the argument that always goes to the court is, look, this goes to the credibility of their testimony, not whether or not they are in fact an expert. A jury can hear, look, I get a 10% cut on this claim if it ends up getting paid, and the jury can make a determination of, do they think that that is going to alter their opinions to a point where we can't trust them? And maybe the answer is yes. Maybe you shouldn't have a contingency fee in a perfect world as an expert, but it doesn't mean you're not an expert. So just make sure you're talking to your attorney about what the regulations are of your state, so that you can know whether or not that fee agreement can still be in place and still be an expert. And if not, make another arrangement to get paid. I mean, we always make sure our adjusters are compensated as experts in the case, whether it has to be based off of an hourly rate or a contingency fee. That really just depends on the state that it's involved in. All right, so that's the rule for estimating. We're coming to the end here. To some of the questions that had come up as people were registering. There actually weren't as many as there usually were, despite there being significantly more registrants. But this was a really good one that I wanted to get out there. When is a PA obligated to participate? In subrogation, litigation, etc. Here's the deal. You don't have to participate in most situations. Subrogation, for example, short of the policy having some odd provision that would bind you, which it generally is not going to have because you're not a party to the contract, forcing you to participate in subrogation is going to be really difficult. Litigation, again, you don't have to participate unless you're subpoenaed. So if you do get a subpoena, you will absolutely have to participate in some form or another. Doesn't mean you have to be an expert. You could just be the fact witness, and you generally will be if you're being subpoenaed, just be a fact witness. But to the extent that you don't want to participate, tell them to go pound sand or send a subpoena, and that is perfectly within your rights to do so. It might be difficult to, explain to the client why you're refusing to participate, but there might be a legitimately good reason for that, and you might want to step back. During a deposition, if opposing counsel requests phone records or other information seemingly unrelated to the claim, are we required to provide it? Short answer is you're not required until you are. If they want to ask you for the records, they can absolutely ask. They can ask for whatever the hell they want to ask for. And you can come back and say, look, I'm not providing my phone records. There's no reasonable basis for it. And they're going to have to go get a court order that tells them either they can or they can't get it. Okay. If the court comes back and says you give it, you give it. If they come back and say you don't, you don't. But without that court order, it's very limited what you have to provide. Here's what I'm going to tell you. And I say this about claims in general. The path of least resistance is often the best path. So if there is a situation where it is easily obtainable, phone records, by the way, not usually that easy to obtain. But if it's easily obtainable, then it can be something that you speak with the plaintiff's representative and turn over if need be. But if they need a court order, tell them to go get a court order. Most things like phone records are going to be hard for a court to actually supply. A quick question from Mike. If we say no to assisting with subrogation, what are the possible results? Well, there's a few things. Again, you could certainly be subpoenaed to provide testimony or provide your records, which is really going to be what they want. They want either your records or your testimony, so they're probably going to just subpoena it to get those. If it's a situation where no lawsuit was filed for the subrogation, they're not going to have subpoena power, so it's going to become more difficult. Really, it's a matter of how difficult are you going to make life for your client. If you don't cooperate with the subrogation, they could make arguments that, as a representative of the client, you really need to be doing this as one of the duties under the policy, and just create problems. Again, path of least resistance is often going to be one of the better choices. Another great question: what should a CV have? So, a CV is your curriculum vitae. In other words, it's a resume. And just like the background section on your expert report, it should have everything that matters, right? I don't care if you worked at a supermarket when you were 18 years old until you were 22, that does not need to be on there. But think of it like a job interview. You want them to know all of the good things that actually matter for whatever that job is. This is identical. You want to have as much as you can in your CV when it comes to your experiences. Another really, really important thing, and everybody should take note that's still on here, you should have a list of cases where you have testified in court as an expert, not depositions, not providing a report, actually testifying. You need to keep the list updated for the past 5 years and be able to provide that. Somewhere, just make notes if you've ever actually testified in court, that includes arbitration, what you have testified for on those cases. When OC recounts his previous boss didn't require PPE or other necessary precautions prescribed by OSHA, what is the right level of smartass to apply? Well, I put this in here because the answer is no smartass, zero smartass. And the fact that there is a gut reaction to be a smartass is the thing that you are fighting against the entire time you're being deposed. You are not a smartass when you're in a deposition. You might be when you're just talking with your friends or even doing an inspection. I know a lot of you are, candidly, and that's okay. Not in a deposition, though. All right. You do not want to have a smartass response for any of the deposition ever. Don't be a smartass. Deposition, or your CV question from Mike. CV could be one page, but if it needs to be longer, let it happen. Let it flow. This isn't actually a job interview, so you want to be as inclusive as possible. So if it needs to be 3 pages, let it be 3 pages. So be it. How long should a deposing witness wait before responding to their allow their attorney possibly object to the question being asked? Great question, but you don't really need to wait. I mean, short of a fraction of a second, any attorney that's any good at what they do will be objecting immediately, and there won't be an issue. You just need to be prepared to stop whatever you are saying as soon as that objection comes through. Um, Generally speaking, if your attorney is taking more than a second or two to object to a question, you got to start questioning what is going on and why that would be the case. Um, but no, the attorney should be quick enough to not have an issue. I want to thank everybody again for doing this. Here's the QR code for pagps2023.com. I think I've driven that home long enough. The other important slide I always want to put up is my direct contact information. That is my personal cell phone and my email. Please feel free to reach out if you've got questions. And as I tell everybody, reach out and remind me as often as you need. Just while I have been prepping this morning, I've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 text messages from different people, all industry related. Although I think one of them was my wife. So 10 industry related texts just from this morning. If I miss it for some reason, please do not feel bad about following up. I'm happy to do it. And a phone call coming in as well. Didn't mute my phone. So feel free to follow up with me. I can't stress enough. If I miss it, it's nothing personal. It's just because I'm doing something like this or in a dep or with my family. So please feel free to reach out. Thank you guys so much. If you need anything down the road, please let me know. And I really appreciate it, guys. Keep learning out there. This is good for everybody involved. Have a good one.